皆様こんにちは。ベーカー&マッケンジー法律事務所の弁護士の増本です。本日は US Litigation Now 3の第2回目といたしまして、トレードシークレット及びサイバーセキュリティに関する米国訴訟について取り扱ってまいりたいと思います。本日のスピーカーをご紹介させていただきます。前回に引き続き、弊社サンフランシスコオフィスのパートナーであります、マーク・グッドマン弁護士です。Hi Mark, thank you for joining us today.
Hi Mika, it's a pleasure to be here. Looking forward to it.
また、本日初めて参加をさせていただきます、パロアルトオフィスのパートナーであります、ブラッドフォード・ニューマン弁護士です。Hi Brad, could you introduce yourself?
Sure. My name is Brad Newman. I am the chair of Baker McKenzie's Global North America Trade Secret Practice, and I'm very glad to be here, and thank you for having me.
それでは本日の本題に移りたいと思います。まずはトレードシークレットリティゲーションについてお話をさせていただきたいと思います。Mark and Brad, today's first topic is a trade secret litigation. So could you explain what a trade secret litigation is?
Sure. So in the United States, most states have a statute that protects what are known as trade secrets, which are competitively valuable information that has a value because it's not publicly known. And the holder of the trade secret takes affirmative measures to keep the trade secret from being leaked to the public. So the classic example in the United States is the recipe for Coca-Cola. Rather than patent it and show it to the world, Coca-Cola keeps it secret, and its value comes from competitors not knowing what the actual formula is. Now, that statute is then used by competitors in courts in all of the states, and there's now a federal trade secret law called the Defend Trade Secrets Act. And so you can go into federal court or you can litigate, say, in California. And what happens is you often find cases between competitors accusing the competitor of hiring away your employees and stealing your trade secrets. And then you're in U.S. litigation. And in the Northern District of California, where we are in Palo Alto and San Francisco, it is one of maybe 3 jurisdictions in the United States that sees the most trade secret litigation between competitors, which makes sense because we're in the Silicon Valley where a lot of tech is marketed and created, etc. And there's a lot of employee mobility between competitors. So you see a lot of litigation here. This litigation is very expensive. It's very disruptive, and it requires a lot of time and energy when you're defending it. And when you're a plaintiff or the victim of trade secret theft and you initiate one of these cases, there are also a lot of risks you're taking on, including, most importantly, you will need to disclose your trade secret to the court and to the jury and to the other side. The trade secret or trade secrets you say have been misappropriated or stolen by your ex-employees or by your competitors or suppliers, vendors, etc.
One thing that I would want to add to what Brad already just mentioned, which is the importance of trade secret litigation, especially in Northern California, where companies in the Silicon Valley and companies that do business, like our Japanese clients who do business in the United States and have exposure to litigation in California and other places, is not just being sued for trade secret violations or suing others for trade secret violations, but we see a lot of trade secret issues coming up in regular commercial litigation cases where discovery is an issue. As we've talked to our clients in Japan a lot about how expansive discovery is in the United States, we're seeing a lot more concentration on protecting trade secrets in regular cases where we're fighting about trade secrets in discovery. So that's one issue that we're seeing a lot of activity where knowledge of trade secrets by our lawyers at Baker McKenzie become very important to know so we can protect our clients' trade secrets when they're engaged in U.S. discovery. in other types of cases. Any other types of issues that you're seeing, Brad, as far as trends in trade secret litigation?
Yeah, absolutely. So having done this for 30 years in Silicon Valley, primarily, when the economy is good, competitors want to sell their products, make money, and stay out of court. When there's a downturn in the economy, suddenly competitors are more likely to try and use the U.S. litigation system as both a revenue generator and a tool to slow down competitors. So we are leaving a lengthy cycle where everything was up and to the right when it came to the economy. And we're hovering around what may be a more drastic downturn, but certainly a downturn in capital markets and every other aspect. And so we're seeing more willingness by competitors to sue departing employees, to sue channel partners, to sue competitors, certainly, when they believe their trade secrets have been compromised. So we're seeing an uptick in it. And then as far as what we're seeing from the courts, there's a definite trend in trade secret litigation because there's so many of these cases now where courts look for a reason to throw the case out. And there is a trend to challenge the trade secret holders' methodology for keeping their trade secret confidential. So we have a lot more willingness by judges to say, you know what, you did have a trade secret, and I was willing to say it was a trade secret, but you didn't take effective measures to keep it confidential. Therefore, you forfeited the trade secret status and your case goes away. We're also seeing one more trend, which is the criminal authorities here, the United States Department of Justice and in Silicon Valley, the CHIPS unit, they are looking for high-profile cases to prosecute and have funds allocated from Congress and locally to prosecute trade secret theft criminally. And there is certainly a bias toward bad actors perceived to be doing things from outside the United States. So that's a trend to keep an eye on when you're confronted with allegations that you're engaged in or your client is engaged in unlawful business practices. There's always a concern there might be some criminal activity and investigation going on against the client accused of trade secret theft.
Thank you. So how can Japanese companies protect trade secrets? Do you have any thoughts on this?
Yes, there are a couple things that are must-dos. One is to make sure internally you've identified what your most important trade secrets are and have taken effective measures that you can show to a court, not just in the United States, the law is very similar in other jurisdictions, that you've taken reasonable measures to protect those trade secrets. Some concrete examples are when employees leave for a competitor. Are you looking forensically at their computer usage in the 30, 60, 90 days leading up to their departure to determine if they have taken intellectual property through any number of means? It's not just attaching a thumb drive to a computer anymore. There are much more sophisticated means. Are you limiting access to trade secrets internally to the least amount of people who need them to do their job effectively? And then most importantly, perhaps, is when you're hiring employees from a competitor, which is perfectly lawful. Are you taking effective measures to make sure they aren't tainting your company and bringing in trade secrets they shouldn't possess, putting them on your computer systems, your servers, and exposing you to a potential criminal or civil action in the United States?
Yeah, I think just to follow up on what Brad was just saying, Mika, it's really important for our Japanese clients to know what trade secrets are. That's sort of the first step. It sounds obvious, but that's what we do with a lot of our clients is identifying what the trade secrets are in order to be able to protect them, and then understand that the real protection of the trade secret is to keep them secret and to take the measures that Brad was just outlining. unlike a patent or trademark or a copyright, which have separate protections and are therefore made public but are still protected, the trade secret's only real protection is that it is secret and to keep it secret. And if it's not kept secret, then why wasn't it kept secret? Was it stolen or inappropriately disclosed, in which case you have a trade secret litigation? Or was it revealed by you by not being careful enough, in which case it's no longer a trade secret? So those are the types of steps that our clients really need to be aware of.
And Mika, if I could say one more thing, everyone knows about cyber preparedness, and that's on the front of all companies' minds right now. But trade secret protection goes hand in hand with cyber protection, not only for the reasons we've discussed, but cyber criminals, threat actors are now changing the way they do business. In the beginning of the cyber attack era, they would access your servers and lock up all of your material. And they would then ask for ransom, and they would base the ransom request off the gross amount of data they took. We have 3 terabytes of your data locked up. If you want us to unlock it, pay us whatever in crypto. Now, threat actors are changing the way they do business, and they are targeting trade secrets. So once inside the firewall, they are looking for the most sensitive corporate documents. And then what they say is not that we have 8 terabytes of your data. What they say is, we have accessed to your most confidential trade secret information. Here's an example. Here's a formula. Here's a manufacturing process or technique your company came up with. Here's the actual documents we have. And if you don't give us the ransom we ask for, we're going to release this to the public, thereby reducing the value, hurting your shareholders, and so on and so forth. So trade secret protection now is not only something that stands alone, but is a fundamental pillar of effective cyber preparedness to make sure that there are the appropriate safeguards around trade secrets. And as Mark said, the first step is, what is it we're trying to protect? What has the most value to our company because our competitors don't know it?
次にですね、まさに今話がありましたけれども、サイバーセキュリティリティゲーションにまた移したいと思います。And Mark, Brad, actually, the next topic is cybersecurity litigation. So, could you provide current trends of cybersecurity litigation in the United States?
Yeah, so I think a good jumping off point is to reiterate that there is a trend of shareholders saying to the board and the C-suite, how could you let this happen? How could you not only let the cyber intruder in, but leave unguarded so much of this information that you've now diminished the value of the company? And so there is a trend for affected parties, stakeholders, to accuse the company's management of not effectively taking the measures to protect the company. There's also now laws that, and it's much more complicated than we can go into in the time frame we have, but there are potential liability for paying the ransom, potential criminal liability to the C-suite for paying ransom to sanctioned individuals. Mark, what other trends are you seeing in cyber?
Yeah, so just quickly, Brad, what we're seeing is cyber criminals coming in and hacking service providers like law firms, accounting firms, and obtaining trade secrets of the clients of those firms that are safeguarded within those firms, and then utilizing those trade secrets to try to extract advantage from not only the firm they hacked, but from the firm whose information was kept by that firm. So we've actually had a couple of clients come to us as a result of that, where their information, they were not hacked, but their information was obtained through a hack of another party. And so that was something that they had to deal with. And again, how do you protect that? You do what Brad was talking about before with respect to your trade secrets. Even when you have to entrust those trade secrets to a third party, make sure you've taken all the steps to ensure that that information is being protected. But in a cyber security situation, that's something that becomes even more important and more of a focus of our litigation efforts in cybersecurity.
So, how can Japanese companies mitigate the risk of cybersecurity litigation? Could you share your thoughts?
So, a good place to start is conducting what's called a tabletop exercise. And that is a simulated cyber attack that you have with your outside counsel and a expert on hand. And it forces the C-suite and the corporation to assign tasks with immediate response plans when you're hit with a cyber attack, because it's too late once you're in the midst of it to figure out who owns what. Out of the tabletop come things like understanding, when do you announce that you've been the victim of a cyber attack? What do you say? To whom? Is your insurance lined up? Do you have insurance for it? What is IT's role? What is HR's role? What is site security's role? What's InfoSec's role? And in the first 24 to 48 hours of an attack, how can you be best prepared to respond and minimize the risk of litigation down the road? And so it's called a tabletop exercise. We run these with a lot of our clients, and it really helps them focus their preparedness. It helps them identify gaps. Whoa, we didn't even think about that. Our comms people have never really been taught what to say, when to say it, how much detail to provide. Who do you have to notify regulatory wise? All of these issues that you're going to be confronted with in the moment while it's happening can be surfaced and planned for appropriately through a tabletop exercise. So we recommend as many clients as possible do these. We can help. We've done them for a lot of clients, and we do them in connection with experts who are on hand, who can also look at the IT and InfoSec structure and help clients come out of it feeling much more prepared.
Thank you very much. 本日はご視聴いただきまして誠にありがとうございました。今後も引き続き US Litigation Now 3のビデオシリーズをご覧いただければ幸いです。本日はありがとうございました。